buenos días.
Very good morning to you all. Colleagues, distinguished delegation of Korea, head of delegation, members of NGOs, friends, conferences, services, interpreters, good morning and welcome to meeting 3211 of the Human Rights Committee. And today we're looking at the fourth periodic report of the Republic of Korea. Yesterday, the committee had put a whole range of questions to the delegation, and the delegation began with their answers, but we ran out of time yesterday afternoon. So we will resume this morning with those answers, and then colleagues will be able to put follow-up questions to the delegation along with the rest of the questions relevant to the list of issues. So I think that everybody's understood the procedure. So without further ado, I'll give the floor to His Excellency so that he can continue to provide the answers to the first list of issues. You have the floor, sir.
네.
Mr. Chair, members of the committee, it is a great pleasure for me to deliver these greetings again to you on the second day of this deliberation on the periodic report of the Republic of Korea. We understand that there are certain questions that have not been answered yesterday. So in order to ensure efficiency and also effective time management for this conference, I'm going to provide you with the answers as the head of the delegation, and for some of the answers that will be given by the working level officials from the government. Some of the members of the committee pointed out that since 2010, when the periodic report was submitted by the State Party, there have not been updates on the current state of human rights improvement. Our delegation is making the best effort possible to faithfully explain to you the current state of human rights improvements in Korea by answering the committee's questions in this deliberation. Also, the State Party's responses to the list of questions submitted this July also supplementary materials distributed to you yesterday, and the opening remarks made at the beginning of the deliberation all contain meaningful, up-to-date information on human rights improvement of Korea. So please refer to that information for your reference.
Let me address the questions posed by Mr. Yuval Shani.
우리 대한민국에서
The question was about the definition of terrorism and cyber terrorism that's used in the state party, which is Korea, for this session. The counterterrorism bills at the moment have been submitted before the National Assembly, and they are currently pending. When it comes to the definition of terrorism and the scope of related activities and affairs, and the potential infringement of fundamental rights, regarding these issues, a range of opinions are currently being presented, and discussions are still underway at the National Assembly. Generally speaking, an act of terrorism is killing people for the purpose of threatening the public, shooting down airplanes, exploding ships and vessels and vehicles, and destroying nuclear reactors. These are the types of terroristic acts that we are utilizing. And in the case of cyber terrorism, we refer to hacking incidents and planting of computer viruses. Utilizing these electronic means, if one paralyzes telecommunication and information facilities or damage information, such acts of attack will be regarded as cyber terrorism. When we implement these counter-terrorist policies, we will make sure that the fundamental rights of the people are unduly infringed upon. That is a strong position that we have. And in the process of legislating on this issue, going forward, we will try to effectively deal with terrorism, and at the same time minimize the potential restriction of liberty and fundamental rights. And that is a direction that we have in mind in pursuing these legislation. Next, let me move on to the questions raised by Mr. Seibert Paul.
사형제도
You asked about the government's efforts to support the legislation of the abolishment of capital punishment. We have already explained to you the official government position on this issue. But to add to that, I want to point out the fact that at the current point, there are bills that are pending before the National Assembly as proposed by the members of the National Assembly. And public hearings have also been held. Regarding this matter, diverse opinions are currently being collected. Much discussion is underway, and we're going to make sure to reach a national consensus in the future. So we would just like to say that there's a lot of effort that is being put in place to discuss this issue. And a member, Mr. O'Rodley, also asked a question about the low rate of prosecution related to the assault conducted by the police. In terms of the number of the charges, number of the reports, this is mainly due to the lack of kindness in the language used by the police officer, and also a show of lack of respect by the police officers, but due to lack of objective evidence. And there is no evidence that would lead to a criminal punishment of such acts. That is why there has been a low rate of prosecution. Thank you.
예, 법무부 인권국장 차경.
My name is Cha Kyung-hwan from the Human Rights Bureau of the MOJ. Let me try to address the rest of the questions that were posed yesterday. First, Mr. Yubar Shani raised a question regarding involuntary hospitalization and the measures that are currently being taken by the government. For instance, a process for raising an objection to such involuntary sterilization or involuntary hospitalization, and some protective measures that are being taken at mental hospitals. Those were the issues that were raised. And Mr. Seibert Fall talked about the reasons for such a high suicide rate in Korea. At the same time, for the respect of life, the types of measures that are being taken by the Korean government to prevent such suicide. That was another question that was posed, and the Ministry of Health and Welfare will provide responses to those questions. My name is Hui Nam from the Ministry of Health and Welfare. Regarding involuntary hospitalization, as was stated in our responses to the list of issues, the revision bill submitted in 2014 shortens a deliberation period from 6 to 3 months and applies stricter requirements for involuntary hospitalization. Under the existing law, involuntary hospitalization is allowed if one of the two requirements, need-based or harm basis, is satisfied, but the proposed revision bill requires both bases and both requirements to exist for involuntary hospitalization decision. An amendment bill to the Habeas Corpus Act submitted before the National Assembly in April 2014 is identified as one of the priority bills to pass by the government, and focused efforts are being made in this regard. Regarding the process for raising an objection in advance to involuntary hospitalization, at the moment, there is no such process that is in place in Korea. However, currently, the National Assembly is proposing to form an evaluation committee on the adequacy of involuntary hospitalization, and that is an effort to put in place a system for public intervention, and such bills are currently under discussions at the National Assembly. Next, regarding the forced sterilization. Not just against women with intellectual disabilities, but also against all women, administering forced sterilization constitutes an illegal act that leads to both civil and criminal charges. Now, regarding the supervision on mental health institutions.
Management and supervision of mental health facilities is not entrusted to private organizations based on a Mental Health Act. It is the state and the local governments that conduct such supervision. Also, in terms of solitary confinement and physical constraints, they're applied strictly to a minimum required extent based on relevant laws. Application criteria and principles are also provided by the government guidelines. For those people that are working at the mental health facilities, they're mandated to receive a human rights related education. And a human rights education manual is also put in place. Next, related to the high suicide rate. The root cause for the suicide is deemed as the rapid social changes and repeated economic crisis resulting in an increased level of stress as well as maladjustment. For the elderly people, they're also feeling a sense of loneliness due to dissolution of family, and also in the case of women, they have the traditional responsibility as a member of the family, and also they have a higher responsibility that is actually imposed by society. And as a preventive action or measure for suicide, we're dealing with the at-risk groups for suicide. For example, elderly, vulnerable, living alone, and suicide attempters. We focus on community-based suicide prevention efforts. For example, for the single senior citizens, elderly caretakers are nurtured as gatekeepers for suicide prevention, and suicide prevention programs are disseminated to these caretakers to enhance prevention efforts.
네,
Mr. Saibotofo also raised some questions regarding ill treatment in the military and the prevention measures against violence in the military and so forth. And the Ministry of National Defense will provide an answer.
I am Park Jin-young from the Ministry of National Defense. Let me provide you with the answers to the questions. The Ministry of National Defense of Korea, in order to strengthen punishment against assault and ill treatment in the military, has proposed a bill to newly introduce the crime of assault in the military, and the bill is currently under discussion at the National Assembly. Also, the Ministry of National Defense, starting from March 2015, established and has been carrying out comprehensive measures to eliminate sexual violence. More specifically, a Gender Equality Center has been set up as a dedicated organization for preventing sexual violence in the barracks, which are now producing some preventive results. Last words on military prison system. Given the fact that military prison could result in physical restriction of military personnel, if a person is to be put in custody at the military prison, a military judicial officer responsible for human rights is mandated to review the legality of such custody, and the commander has to respect the opinions of the review by the judicial officer in taking actions. So, a cautious approach is being taken to operate the military prison system. Thank you.
네, 이제
Next, I believe that this will be the last response to the questions raised by the members yesterday. Mr. Lee raised a question regarding the independence of the NHRCK. The MOJ will provide an answer to this question. My name is Eugene Oh from the MOJ of Korea. There have been some suggestions made by the NHRCK, and we are trying to reflect those suggestions as much as possible in these legislative efforts. In particular, functional immunity will be provided to the members of the NHRCK, and such a bill has been discussed at the State Council of the government and has been submitted before the National Assembly at the proposal of the State Council. I believe that the bill is being handled very expeditiously because the government is recognizing the importance of maintaining independence of the NHRCK. We have been making very proactive measures in this regard. In accordance with the guidelines, recently, the National Assembly has been pursuing an open recruitment for the members of the NHRCK. And in July of this year, the presidential office has opened up the chair's position for recruitment. The NHRCK itself is receiving recommendations as to its members so that they can submit that to those people who have the responsibility for appointment. Concerning the statistics on the complaints handling by the NHRCK, for instance, concerning the torture by the police in Korea, there has been no significant change in terms of the statistics. Concerning the number of complaints submitted before the NHRCK will be translated into English and will be submitted later on. Thank you.
이것으로 어제
So this concludes the response session for the questions that were posed by the members from yesterday.
Thank you very much to the distinguished delegation for the responses provided. So we'll move straight into the colleagues' questions. And I'd just like to reiterate, these can be both follow-up questions or indeed the questions belonging to the second stage of the list of issues. I'd like to ask you to make sure that your questions are focused so that we can use the time available in the most efficient way possible. So without further ado, I'd like to give the floor to the first speaker on my list, Mr. Shani, please. You have the floor.
Thank you, sir. And I thank the delegation for their very comprehensive responses. I will just note very briefly with respect to issue number 9, which I discussed yesterday, dealing with the definitions of terrorism. I just want to clarify to the delegation that the position of the committee is that by and large, it is preferable to conduct the combat against terrorism within the context of existing criminal law. And as long as the exercise of criminal law conforms with the principle of legality and the need to respect legal certainty. What is difficult or raises concerns is when the counterterrorism measures are based on open-ended definitions found in existing legislation or are conducted wholly outside the framework of existing legislation. And it is important, therefore, that the state party not only respect human rights in the course of implementing its counterterrorism measures, but also when actually adopting the relevant definitions within its legislation or in selecting the specific provisions on which it plans to rely. And from what I heard from the delegation, I am not still fully persuaded that the proposed definitions, especially for cyberterrorism, would meet the relevant international standards. I was struck by the breadth of the definition that was invoked. I move on to discuss other issues from the second half of our list of issues, and I will start with issue number 14, which deals with the right of persons to be brought promptly before a judge. Now, I first wish to commend the state party for responding to some of the issues raised in our 2006 concluding observations, especially the revisions that were passed in 2007 to the Criminal Procedure Act that shortened the period for requesting a warrant under the urgent arrest procedure. Still, if I understood correctly, and I stand to be corrected by the delegation, the period of detention without judicial review, even now, is slightly longer than what the normal standard that this committee recommends. If I understood correctly, the warrant has to be issued within 48 hours from the moment of arrest, but the person would be brought before a judge within 24 hours from that point in time. So if I understood correctly, the actual period for presenting a defendant before a judge would be 72 hours, but as I said, I'll be glad to be corrected. I'm not certain that we have fully been satisfied with our concerns with respect to the other procedure, namely in ordinary, non-urgent detention procedures. Again, if I understood correctly the information provided by the state party, a person may seek habeas corpus, namely to be presented before a judge within 48 hours from the moment in which he or she makes the request. Our position in General Comment 35, which interprets Article 9, Paragraph 3 of the Covenant, is that the state must provide proprio motu, namely without the defendant requesting it, it must present the defendant or the person detained before a judge for judicial review. And again, I would like the delegation's clarification as to whether we understood correctly the procedure which takes in place. Moving on to other forms of detention, my colleague, Madam Wotoval, will speak, I believe, later about immigration detention, so I will not delve on this issue. I just seek clarification as to whether there are any time limits with respect to the length in which individuals can be detained under immigration detention. I'm not speaking about habeas corpus, I'm speaking about the ultimate length of detention in immigration proceedings. It has been alleged to us that migrants could be detained for an indefinite period of time under that system. Now, with respect to juvenile detention, I have one question, and this goes to the issue of the pretrial detention and the relationship between the pretrial detention and the sentence. it has been claimed before us that unlike for adults, for juveniles, the pre-trial detention period is not deducted from any sentence which is being decreed by the court. Again, I would like the delegation's comment as to whether this information is accurate, and if so, any explanation we can receive on this. And finally, on this point of issue 14, I would want the delegation to address the issue of the treatment of the DPRK defectors and to explain what legal safeguards are being afforded to this group of individuals who are being detained in the Defector Protection Center. I understand that their detention there could be for up to 6 months. Could you please clarify what procedural safeguards are in place for them, specifically whether they're able to access counsel, whether they are able to invoke the Article 214-2 of the Criminal Procedure Act? Are they informed of the right not to self-incriminate themselves? We have also been informed that some defectors which are not entitled to protection status are then being deported without any legal or quasi-legal process. And again, I would appreciate your comments in this regard. Moving on to issue number 22, which deals with the religious education or secular education rather. And here the concerns we would want to take up with the delegations are not so much with the stated policy of the state, which appears to be well within the scope of the covenant, because we understand that the general chapter of the curriculum of elementary and secondary schools does require schools to provide alternative options for students with respect to religious classes and ceremonies. It's rather whether these options are really exist. These options truly exist in actuality, namely it's to what extent is the policy satisfactorily implemented. We have information that in most surveys that provide that for most students who go to religious schools, these options are not being actually provided, and we would want the state party to provide clarifications as to how it is implementing the decision of the Supreme Court on this issue. Moving on to issue number 23, and I'm moving quite quickly, though these are serious issues in the interest of time. So issue number 23 deals with freedom of expression, defamation, and online defamation or online restrictions on online expression. These are very important issues, as one can imagine, and which are really at the core of our covenant. So can you please first explain to us what is the impact of the court's, Constitutional Court's 2010 judgment on the Framework Act on telecommunications? If I understood correctly, the court struck down Article 47, Section 1 of the Act, which penalized publicly making a false communication for the purpose of harming the public interest, because the term harming the public interest was too broad. Now, this is, of course, a very worthy legal standard, which is compatible with the way that our committee would approach similar issues, because as I indicated before, we believe that states, while they may introduce some restrictions on rights and on free speech, these restrictions must be carefully defined and meet conditions of necessity and proportionality. But the question I have is whether the same logic does not apply to other provisions of the Act which are still being relied upon. So, for instance, Section 2 of Article 47 criminalizes false statements which are designed to benefit oneself or a third party, or to inflict damage on a third party. And And they seem to be also quite open-ended in nature, as is the offense of interference of business under Article 314, Paragraph 1 of the Criminal Code, which appears to be also quite uncertain in its scope. So this is one set of issues about the Constitutional Court decision. Secondly, I wish to express our regret about the state party's lack of interest or lack of intention in reviewing the legislation on defamation. Let me state again that it's been the consistent position of our committee. It has been explicitly spelled out in General Comment 34 that state parties should consider decriminalizing defamation, and that imprisonment is never an appropriate penalty for defamation. We accept that, of course, as I mentioned before, that freedom of speech does carry certain responsibilities, and that there are social interests that could be protected by defamation laws, including the interests which have been identified by the state party, namely the reputation of others, privacy of others, and general happiness. But our position is that by and large these interests could be adequately protected without invoking criminal law, for instance through the application of civil law, and that such an approach is more consistent with respect for freedom of expression, and I would appreciate the government's reflections on this point of view. Now, these comments and these concerns about freedom of expression, defamation apply a fortiori with respect to speech that is directed to criticize the government. In there, we would like the state party to provide us with explanations as to why criminal charges were invoked against those who spread false information through publications, allegedly false information through publication criticizing the government following the tragic Seoul ferry disaster. It was alleged that such false information damaged the reputation of public officers, which is a very difficult concept because it may stifle free discussion about such crucially important issues. Also, can you explain to us what is the social interest which would justify 7 years of imprisonment with hard labor under the provisions for defamation of the Act on Promotion of Information and Communications Network, Utilization and Information Protection, which seems to be a very harsh penalty. And again, I would be grateful to the state party for its clarifications in this regard. Another point I want to raise, and I apologize for the length of this specific set of issues, but as I said, they really go to the heart of our covenant. What is the interplay between Section 307, Paragraph 1, which covers both false and true statements, and Paragraph 2 of the same section, which alludes only to false statements? So what's the relationship between truth statements, which could be criminalized, and solely for the public interest standard of Section 310? Could you please explain to us? I'll rephrase the question. Under what circumstances can a person be criminally charged for defamation for providing a truth statement? Okay, which is for us again a very difficult notion that someone would be criminally charged for speaking the truth. And whether the term solely for the purpose, for the public interest is not too narrow. So for instance, just to give you a hypothetical example, if I was a business person who was participating in a public tender and I lost in the public tender, and then I have information that this public tender was corrupt, that the procedure was corrupt, and I want to expose this. Of course, this would generate harm to the public officials that administered the tender, and maybe also to my business competitors that won tender. But it appears that if I understood correctly the legislation, I would not be able to invoke the defense of truth because my speech is not solely for the public interest. I have something to gain from this information. So I would appreciate any information you can provide us with this issue. Another issue I want to raise is Article 44 of the Act on Promotion of Information and Communication Network, Utilization and Information Protection. It's a long title. And specifically, my question is what safeguards are in place to ensure that this provision is not used to stifle online expression. We have received, thank you. We have received information that there is massive use through the Communication Standards Commission of advising service providers to remove information, and that hundreds of thousands of messages were removed in the last 5 years. So again, any clarifications in this regard would be useful. And finally, and I'm sure this is a relief for all of us, can you explain to us the rationale for Article 27 of the Public Officials Service Regulations, which prohibits public officials from criticizing government policies which are not related to official duties? And specifically, I have a question whether why were public officials, for instance, prohibited from participating in a protest which demonstrated against cuts in their own pensions? Okay, and if this is true that they were prohibited from participating in a demonstration involving their own pension rights because it's not covered by Article 27. Now, moving on to issue number 24, which deals with the National Security Act. And now, I thank the delegation for the information provided in response to our question in this respect. I appreciate the sensitivity of the issues. And I also know the position of the Constitutional Court on the constitutionality of the Act. I would appreciate if you could explain to us the essence of that position, and especially the question of whether the logic of open-ended nature of provisions, which we have seen the Constitutional Court invoking with respect to freedom of speech, doesn't apply here too. I'm concerned especially about the notion of dissemination, which appears in Article 7 of the National Security Act. And it is, for instance, has been represented to us that Article 7 was used to prosecute a person who was retweeting tweets from the Twitter account of the North Korean government, when this person meant to use these tweets in order to mock the government of North Korea, but nonetheless that person was prosecuted for disseminating information which is anti-state information. I should say that the person was convicted and he was eventually acquitted by the state party. So we are not concerned so much with the actual disposition of the case, but with a very broad authority that the government appears to exercise, which again may stifle free speech and constitute a chilling effect. And it's always sensitive when you have a provision which is designed to defend democratic freedom, that the state, when the state invokes this provision in ways that essentially curb democratic freedoms, because they do not allow individuals to freely express themselves. And finally, on this issue, I wanna deal with the dissolution of the UPP party following the decision by the Constitutional Court from 19 December 2014. Again, we are not in a position, of course, to evaluate the legal reasoning under domestic law that the court has employed. I wish, however, to state that the committee's position, which was expressed in General Comment 25, has been that restrictions upon the right to stand for elections must be justified on the basis of reasonable and objective criteria. And the two concerns which I want to flag is that first, again, the issue of the open-ended criteria that had been relied upon by the state in its motion for disqualification, namely that the party operates contrary to the fundamental democratic order. Another concept which, as you can imagine, raises some concerns as to whether respect of the democratic order to what extent it could serve as the basis for preventing parties to participate in that democratic order. And specifically whether the court had invoked in its decision additional concepts which could support this idea of threat to democracy, namely resort to violence, whether it has been sufficiently established that the party in question explicitly calls for violence, and whether the threat in question is likely. It is my understanding that the party which has been disqualified, UPP, had very few seats in the National Assembly. I think it was 5 seats. So it was not on the verge of taking control over the state. And when you do not have what sometimes is called clear and present danger, and if, as alleged, you do not have explicit call or explicit endorsement of violence by the party as part of its official platform, such a decision raises concerns for us, which I would want the state party to address. And the other element is the issue of whether there are other alternatives for addressing the threat to the democratic order. It is my understanding that while the Constitutional Court was addressing the dissolution proceedings, there were also criminal charges which were addressed versus certain officers, certain members, prominent members of that party. And the question is whether the use of criminal proceedings, and I understand that they have been convicted of some charges and acquitted of some other charges, and I would not wish to express any view on these proceedings, but the question is whether it wouldn't suffice to address the threat through addressing any specific violation committed by any specific member of that party. Going through to disqualification of the entire party appears to be a quite radical step. I do acknowledge that this is the second time that this has happened in the last 50 years in Korea, so that it is not a very frequent step, but still it is generating some worries and concerns. So I apologize for taking the floor for so long, and I look forward to hearing your reactions and responses. Thank you.
Muchas gracias, señor Shani.
Thank you very much, Mr. Sheni. I now give the floor to Ms. Vertefal. You have the floor.
Thank you, Mr. Chair, and also thank the delegation for the answers they have provided, and also thank for the information on the issues I'm going to post. I'm going to ask questions on issue number 15, 18, and 28. I thank you for the information on issue number 15 with regard to the Immigration Control Act. And you have described the procedure for the refugees and asylum seekers. And in your reply to that issue, in the last sentence of paragraph 42, you stated the average detention period in 2014 was 12.2 days. But I have information that, and then they asked me not to disclose the name of the victims, but I have here that as of September 2015, there are a total of 17 asylum seekers which are detained in the immigration detention centers. And as of the 18th of May 2012, there was somebody from Nigeria. As of the 23rd of August 2012, somebody from Myanmar, and as of 24th of October 2012, that were 36 months, also somebody from Nigeria. So maybe you can comment on this. And referring to the Article 36 of your Immigration Control Act, and especially paragraph 1 and paragraph 2, we have information that in practice, approvals are issued automatically as long as the deportation order is still in force. And in the case of asylum seekers, deportation is not possible while review of the asylum claim is still pending, and that results in an indefinite detention. Turning to issue number 18, that is on the trafficking in persons. Yesterday you talked about actually another issue, but still you mentioned the seafarer case and the forced labor of adults and children. I don't know if these two cases are also related to human trafficking. We thank you for the question on the way you treated the case of the seafarers. In your reply in paragraph 53, you pursue the case of the seafarers with the legal assistance of Indonesian authority, and that is what we are very pleased of. We also thank you for the statistical data in paragraph 55 of the replies of the list of issue. We noticed that in 2014, there were 507 cases registered. Compared, that was a very high number compared to the other years. Can you explain the increase of the cases of human trafficking? And as of May 2015, so in 5 months, you had 185 cases of human trafficking. Maybe what do you expect as the end of at the end of this year? We have also we have a case because, and that happened because as a consequence of the definition of human trafficking in your country. In 2000, you signed the UN Protocol to prevent, suppress, and punish trafficking in persons, especially women and children. So the trafficking protocol. And I don't know if in the meantime you have ratified it. I hope so. But while trafficking is a criminal offense in South Korea, the current definition is not consistent with international law, including Article 3A of the Trafficking Protocol. Under Article 28, 289, the first till the third paragraph of South Korean Criminal Act, you have defined trafficking in persons. And I'm not going to repeat it because you know your Criminal Act, of course. This definition of South Korea criminalizes only the act of buying and selling, which makes it difficult to prosecute individuals who have recruited and exploited the labor of migrant agricultural workers through contractual deception. As a signatory of the trafficking protocol, you are obliged not to undertake measures to defeat the object and purpose of the protocol. So we urge you to amend the definition. And I have an example because there was a Filipino woman, that's this year, she entered Korea with an entertainment visa with the expectation to be a singer, but then she was sexually exploited. The authority, instead of treating her as a victim, she was treated as a criminal. So I think that is why we, or the state, needs to amend its definition of trafficking in persons. Turning to issue number 28, that is on the registration of birth. Referring to your reply on issue 28, my question is, because you have stated that who are registered by birth, my question is, what happened to children whose parents are non-Korean, for instance, migrants, refugees, but the children who are born on the territory of Korea? How do you cope with this situation? What if the parents are undocumented, and how did you register these babies? Can you also tell us what is the status of the amendment bill strengthening guardianship of the government? Has it already been adopted by Parliament in the meantime? And then I would like you to comment on a statement. A recent news report detailed how a Vietnamese woman abandoned her baby daughter so the child could obtain Korean citizenship. This child was later placed in an orphanage, and although the mother continues to visit her, she refuses to acknowledge her as her daughter for fear that the child's citizenship may be taken away due to the mother's undocumented status. I would be very happy if you comment on this. And with that, Mr. Chair, I come to my end, and I will thank the delegation in advance for their answers. Thank you.
Muchas gracias a usted, señora.
Thank you very much, Ms. Vateval. The next speaker is Sir Nigel Rodley. You have the floor, sir.
Thank you very much, sir, and thank you very much to the delegation for the answers we've received so far. I particularly appreciated the answers to some of my questions that I received today, which were somewhat more responsive than some of the answers I received yesterday. If I may say, it will save the delegation time, and it'll save us time if the delegation assumes that the list of issues was prepared after we had read the report, and that our follow-up questions are submitted orally after we have read the written replies. Accordingly, it's not necessary for the delegation to repeat information in the report, and it's not necessary for the delegation to repeat information in the written replies. They can assume that our questions are trying to take us beyond what is already there. And so repetition of what is already there is simply not the best use of the time of either the committee or the delegation. An example was the question of the definition of torture. we were referred to Article 125. My question had been, does Article 125, the existing law relating to torture and cruel treatment, cover mental torture? I didn't get an answer to that. The answer probably lies in the definition of cruel treatment, cruel acts, because the first word is violence. It's violence and cruel acts. Do cruel acts cover mental torture? They either do or they don't. It would be useful to know. The delegation did helpfully point out that, yes, there was a statute of limitations for Article 125. What is the length of that statute? What is the statutory period? On the issue of solitary confinement, I was very interested to find out that each institution has its own rules. I must say I've never heard of that before. Does the state party not feel it necessary for there to be national rules relating to when people may be put in solitary confinement, when prisoners may be put in solitary confinement or not? The idea of it being up to each institution is totally novel to me, if the idea is to have a law-abiding penal system. So did I understand that correctly? Did I also understand correctly that solitary confinement can be awarded indeed for up to 30 days, which does seem rather long and possibly excessively long within the meaning of Articles 7 and 10 of our covenant? As to the appointment of outside members to the body that awards these things, my question had been not that they are there, but how they're appointed. My understanding is that they're appointed by the warden, him or herself. Is that correct? Obviously, if it is correct, it raises questions as to the genuine independence of the body in question. On the issue of protection devices, I noticed that there was reaffirmation that they're only supposed to be used to prevent escape or suicide. So far, so good. They cannot be used for punishment or disciplinary purposes. So far, so good. But we were assured that there was a high-level body that does an audit of these things. I take it that high-level body, whatever it is within the institution itself, and therefore it may not necessarily meet the need for independent control and monitoring of possible abuse as well as use of protective devices. Complaints may be made apparently to the NHRCK. It would be very useful to have information from the state party on the statistics of such complaints to the NHRCK or anywhere else, though I can also see that it may be rather difficult for people in detention to make such complaints, and the state party may wish to think harder about how to ensure compliance by the prison staff of the rule that protective devices must not be used for disciplinary purposes. Now I'm going to go on to new issues, starting with issue 16, access to counsel. I've read the response on access to counsel. It seems to, the state party seems to have ignored the previous concluding observation on this from this committee. If one reads what the state party says about the access to counsel, access which I believe was found to be a constitutional right by the Constitutional Court as early as 2003, it's a bit difficult to follow. The participation of counsel may be restricted during the interrogation. I'm quoting from paragraph 43 of the list of replies. interrogation if the participating counsel clearly hinders interrogation, such as unduly interfering in the interrogation, conducting improper actions or words without a prosecutor's consent, answering the interrogation on behalf of the defendant, or inducing changes to the statement made or specific answers or testimony. I must say that on its face it almost looks like they have a right to counsel as long as the counsel does nothing, and those conducting the investigation don't mind the person being there. I do note that civil society, including the Bar Association, is not overly impressed with the unrestricted access of counsel. According to information we have, in late 2014, the Ministry of Justice requested disciplinary actions on human rights lawyers. Among them, attorney In Suk Kim was accused of advising a suspect who participated in a rally asking for truth regarding the sinking of the Seawell ferry to practice the right to remain silent in the investigation. And attorney Kyung Wook Jang was accused of persuading the suspect of a spy case to make a false testimony. Apparently, the Korean Bar Association rejected the disciplinary action request, stating that it cannot be considered that attorney Jang urged the suspect to make false testimony, and that the right to remain silent is a right granted to suspects by the Constitution and the Criminal Procedure Act. And therefore, attorney Kim's advising the suspect to practice the right to remain silent can't be considered to be violating his duty. Is it really the case that advising a client to remain silent is interfering with the investigation? Mr. Chairman, I'd be very grateful to have that clarified by the delegation. As I say, that there is also another issue that has arisen that has been alleged to be the result of oppressive questioning without the right to counsel, that I would like the delegation's comments on. And this, interestingly, arises out of a case where an allegation of torture was taken seriously, substantial allegations of torture, and so there was an investigation at the police station into those who may have been responsible for the torture in question. So far, so good. That's encouraging. Except that it seems that a number of the police in that police station subsequently committed suicide, and it has been put to us that those suicides were the result themselves of oppressive questioning without the benefit of counsel. A rather untypical case in any country, I guess, but I'd be very interested to have the state parties' response on that. And finally, in relation to the question of access to counsel, apparently the Korean Bar Association conducted a survey this very year. Apparently 48.5% of the respondents answered that they've experienced unfair treatment from investigators. This is lawyers. Among those who experienced unfair treatment, 56.6% answered to have experienced restraints on expressing views, such as raising objections on unfair interrogation manners. 46.5% responded to have experienced coercive actions and or abuse of power by investigators. 45.1% reported to have been prohibited from making notes of the interrogation, and 6.8% answered to have been banned from participating altogether. Again, I'd welcome the state party's response to this survey by the Korean Bar Association. Finally, in relation to issue 16, the situation at Incheon International Airport Detention Center, I'm pleased with the new information we have that Council do now have access to people who are in that detention room, at least since the use of the room was found to be unconstitutional. However, NGOs do tell us that potential deportees who are held, who might otherwise have been actually forcibly detained in that room, are effectively forced to be kept there anyway, because if they don't agree to stay there, they won't have the means to secure shelter elsewhere or food or clothing. Is that the case? That's it for issue 16. Now on to issue 21, the issue of conscientious objection. The reply on issue 21, excuse me, the reply on issue 21 suggests a complete refusal of the state party to accept its obligations under Article 18. The state party simply repeats its position that the specific situation of the state party requires it to maintain the current situation in which there is no alternative service permitted, and that so does public opinion. And indeed, as far as public opinion is concerned, it's apparently undertaken research that confirms that. I note in parenthesis that civil society tells us that there is other research asking slightly different questions that may not necessarily confirm the research conducted by the state party. In any event, I have to note that freedom of conscience, like the right to life, I noticed this morning the response that somehow the abolition of the death penalty has to depend on a national consensus. Of course, national consensuses are rarely available for sensitive human rights issues, much less the death penalty, where typically jurisdictions abolish it, and it takes public opinion some 25 years, according to one international study, to catch up with abolition. So by waiting for public opinion to get there, we don't get abolition. And the same could well be true with issues such as freedom of conscience when it comes to conscientious objection. Basically, human rights are not matters of public opinion polls, Mr. Chairman. Meanwhile, it's also not terribly clear what it is about the specific situation of this specific state party that requires it to buck the trend of recognizing alternative service and leading to the reality of some 600 persons being detained at any one time in the state party for conscientious objection. And meanwhile, I simply can't hide the sense of disbelief I felt when reading paragraph 70 of the list of replies, where, according to which the state party intends to publish personal details of conscientious objectors. What is the purpose of this? Isn't it an incitement, an invitation to public persecution, to harassment, or worse? And this would be on top of the problems CEOs already face in finding employment, notably in government and government-linked organizations and major private companies that require proof of military service before they employ people. Frankly, it all seems like a direct challenge to the committee, making the delegation's protestations of respect for it ring somewhat hollow, not to mention the lack of respect for the dignity of the conscientious objectors themselves. I do believe that the NHRCK has actually advocated that the state party develop a system of alternative service in line with what the committee has advocated, and the state party should perhaps take its National Human Rights Commission more seriously on this issue, even if it's not prepared to take this committee seriously. Finally, on issue 26, this is the question of freedom of assembly. Because time is running, I'll not go on at length about the issue, but it is rather confusing. I do need some clarification. We're told that there isn't a question of prior authorization of assemblies, that permission isn't required. It's just simply necessary that the police be informed, presumably, so that they can ensure that everything runs smoothly. But nevertheless, apparently some demonstrations are then banned. Now, if the result of going to the police to ask, to say that a demonstration is going to be held, and then the demonstration is banned, it sounds awfully like an authorization process to me. And so I could use some clarification there, though I appreciate the information according to which very few demonstrations are in fact banned. I'm not also clear what is the legal status of a demonstration that has not been notified, that has not been registered with the police. Does that justify its dispersal? My understanding is it doesn't. It only justifies certain measures to individual leaders or participants, according to what we're told is constitutional court rulings in this respect. So again, it's not clear to me whether or not an unauthorized or unregistered demonstration may be dispersed at will by the authorities. And when the authorities are authorized to disperse a demonstration, what limits are there to the use of force? What instructions are there to the use of force, especially in relation to a peaceful, non-disruptive demonstration? And the kinds of things that worry us in relation to this issue are information we have according to which the 18th of April 2015 memorial service at Seoul City Hall Square in relation to the Sewol ferry tragedy, where tens of thousands of people marched some 500 meters to Gwanghwamun Square, pardon the pronunciation, where a group memorial altar was placed to offer flowers. But they were stopped by a bus barricade of the police. The police sealed off the Gyeongbok Palace, the square, and the Sejongro intersection with security cordons, disposing approximately 470 police buses, including the specially designed 18 trucks and security fences. In addition, a large police force of about 13,700 personnel from 172 units were mobilized for the crackdown. That is the information, of course, we're getting from civil society. The delegation obviously is absolutely free to refute it. But we even have information according to which registered assemblies are confronted with obstacles that would defeat the purpose of the right to assemble. So it's alleged to us that the police take excessive policing measures supposedly designed to keep the assembly in line with the plan that was approved at the time of registration. A large number of police forces often barricade the assembly for the pretext of preparing for possible violence, but thus cutting off the participants from passers-by and therefore frustrating the purpose of the assembly. And if the participants march, allegedly excessive blocking comes to the point where essentially that itself leads to tensions between the demonstrators and the police. So those are some of the concerns we've had. The amount of information we have, the number of incidents that have been put to us is far too numerous to be able to put to the delegation, but it would be helpful to have some reassurance that about demonstrations that the government has allowed and that the police have allowed, where the government itself and possibly the police itself are targets of the demonstration. Thank you. I'm sorry to have gone on for so long, Mr. Chairman, but the issues required a certain amount of attention. Thank you very much for giving me the floor.
Muchas gracias.
Thank you very much. Ms. Cyberfor, please.
Thank you very much, Mr. Chairman, and I also would like to thank the distinguished delegations for the information given this morning. Today I would like to ask questions number 17, 25, and 27, which are related to the conditions of detention, freedom of expression, and the right to form trade unions. First of all, with regard to issue number 17, the situation of persons deprived of their liberty. According to our information, overcrowding in correctional facilities is indeed a serious issue. I understand that new constructions are underway to build more correctional facilities, and I wonder whether the government is also planning to regulate the minimum cell space allowed per inmate. The conditions in immigration detention appear to be particularly deplorable, and my dear colleague, Madam Waterfall, has already referred to it, so I can be rather short in this respect. My focus here is on the conditions there, and I would like to know whether there have been any efforts to, indeed systematic measures to improve this situation. I would appreciate if the delegation could respond to allegations that there is solitary confinement used arbitrarily and in a punitive manner in immigration detention, and that communication of detainees with the outside world is restricted. Now, with respect to medical care in detention more generally, we have information according to which the medical treatment of prisoners is insufficient. Is it right that more than 1/3 of all inmates who died in correctional facilities from 2004 to 2013 died because their application for a suspension of their detention had been denied or prolonged? A final issue that I would like to raise in this respect is access to justice for prison inmates. I would like to inquire about a 2010 guideline by the Ministry of Justice, according to which prison inmates have to pay for convoy fuel costs and highway toll fees if they need to appear in court for civil, administrative, or family litigation. How can this be reconciled with the right to access to courts under Article 14 of the Covenant? I fear that the imposition of such costs, even if they are collected only after the proceedings, may deter prisoners from challenging unfair treatment in detention. I turn now to issues number 25 and 27, which relate to the freedom of expression, peaceful assembly, and freedom of association. In the replies to issue number 25, the state party denied that journalists and human rights defenders were subjected to harassment and intimidation. However, the report by the Special Rapporteur on the situation of human rights defenders of 2013 reports incidents of harassment, intimidation, and indeed illegal surveillance of journalists working on human rights-related issues. I would like to inquire about the use of the criminal court to restrict the freedom of peaceful assembly and the freedom of expression. Apparently, the government resorts to several criminal provisions in the Criminal Act in order to bring charges against human rights defenders. I will only refer to three of them: the obstruction of business, the obstruction of performance of official duties, and general obstruction of traffic. I wonder how this can be reconciled with Article 19 and 21 of the Covenant, and I would like to recall that such restrictions can only be imposed under the standard of strict proportionality and necessity. Another example which gives the impression that criminal provisions are used to suppress freedom of expression and assembly is the case of Mr. Lai Gon Park from the Seoul Ferry Disaster Coalition. We received information indicating that Mr. Park was detained since 17th of May this year and indicted on charges of organizing illegal protest, refusing to disperse, general obstruction of traffic, special obstruction of public duty, invalidity of public documents, and destruction of public goods. My question is as follows. Under the current law, can the organizers of a demonstration be held criminally accountable for violent actions or unlawful behavior of other participants of an assembly? Furthermore, we have information according to which a banner in the Mapogu neighborhood of Seoul was banned because it contained words such as lesbian, gay, bisexual, and transgender. How can this be reconciled with the freedom of expression? Lastly, I would like to turn to issue number 27, which is about the right to form and join trade unions. My dear colleague, Sir Nigel, yesterday referred to the declaration made by the State Party under Article 22, which refers to its domestic legal system, and we have also received a comment by the distinguished head of delegation. But I would like to stress that the content of this declaration is difficult to interpret as a reservation in the first place. And I would like to refer to statements made by several of the other states parties in this respect. Even if the declaration is interpreted to be a reservation, its validity is highly doubtful considering its vagueness. Having said that, I would like to inquire about the implementation of Article 22. In particular, I would like to know why is the KGEU not recognized as a trade union under the law? Again, I would like to refer the proportionality principle, which is firmly established under the Covenant. I wonder why should it be necessary to restrict the freedom of association to exclude dismissed civil servants? Mr. Chairman, this brings me already to the end of my questions. I look forward to the replies by the distinguished delegation and thank you in advance.
Muchísimas gracias.
Thank you very much. Thank you, Madam Saiba, for Mr. Iwasawa, please.
Thank you, Mr. Chairperson. Anyon Hashmanika. I thank the distinguished delegation for giving detailed responses to our questions in the first round of our dialogue. I have one follow-up question on answers given for issues in the first half of the list of issues. Yesterday, with regard to issue number 6, I asked a question on Article 92(6) of the Military Criminal Act. Our concern was the criminalization of same-sex sexual activity in the military. The delegation explained the human rights education in the military in general, and I'm afraid that my question remains unanswered. Turning to issues in the second half of the list of issues, I will ask some questions on issues numbers 19 and 20. Mr. Chairperson, please rest assured that I will not speak as long as yesterday. I start with issue number 19 on the right to privacy. In the written replies, the state party explained that blood tests are given to soldiers and prisoners of correctional facilities, and consent of prisoners must be given before conducting the test. Yet persons who are admitted to prison for the first time are required to have health tests, and such tests include HIV tests. Thus, it seems to me that an HIV test is in fact compulsory for prisoners, is it not? Foreigners who stay in the Republic of Korea for more than 90 days and work as foreign language instructors must submit an HIV test certificate when they register. The state party explained that such procedure is carried out for the purpose of providing a safe public health environment to juveniles. Korean nationals and ethnic Koreans from abroad are exempted from such HIV test. Could the distinguished delegation please explain the reasons for the different treatment? I now turn to issue number 20 on surveillance of private communications. We thank the state party for providing the detailed information on this issue. According to information before us, the police carries out a so-called base station investigations. Namely, they receive mobile phone signals picked up at the wireless base station near protest sites to identify participants. And base station seizure of communication metadata accounts for more than 90% of seizure of communication metadata. The seizure requires approval of the court, but approval is almost always granted. In the written replies, the state party denied that the police conduct base station investigations. Could the distinguished delegation clarify whether the state party does or does not conduct base station investigations? Although wiretapping and metadata retrieval of communication confirmation data both requires permission from the courts, the rejection rate of such permission is very low. Access to metadata to track location information is reportedly permitted by the government when considered necessary for an investigation, and that's quite extensively. The National Human Rights Commission of Korea recommended in 2014 that the request of metadata from the government should be granted only after permission is given by the court and only when there is a reasonable ground to believe that the suspect committed a crime and the metadata is related to the relevant case. Furthermore, under the Telecommunications Business Act, Internet carriers are allowed to provide subscriber identification information to the government without substantial restriction. There is no need to get permission from the court. This practice has been criticized as easily leading to illegal surveillance on internet users who are critical of the government. The National Human Rights Commission made a recommendation in this regard as well. Yet the recommendations of the Commission seems not to have been adopted by the government. Could the distinguished delegation explain the reasons for the non-adoption of the recommendations of the Commission? Has the state party considered making the requirements for the government access to personal data stricter? Thank you, Mr. Chairperson.
Muchas gracias, señor.
Thank you very much, Mr. Iwasawa. Mr. Politi, you have the floor.
Thank you, Chair. This is the first time that I'm taking the floor during the dialogue with the Republic of Korea, and therefore I wish to convey my warm welcome to the delegation and thank the head of the delegation and all its members for the information and the responses provided so far. I can be relatively brief, Mr. Chairman, since Mr. Shani has taken care of most of my concerns relating to the issue of treatment of DPRK defectors. But I would like to ask a few additional questions on this same matter. The first one is very simple and relates to the exact number of these individuals admitted to the protection centers in Korea. Does the government and delegation have updated statistics about this number with regard, for example, the last 10 years? Are we talking about a few thousand people or a larger number of these defectors that are admitted to the protection centers and they have to go through a procedure that, as far as I understand, starts with an inquiry procedure about their identity, background, reason of migration, and I understand also that based on the results of this inquiry, which is conducted mainly by the National Intelligence Service, the centers decide whether to admit the defector to the program of protection or to open a criminal investigation, often over accused spy cases. And in this respect, I would like to ask the delegation, I would be grateful if the delegation could confirm that this first inquiry at the center is considered by the government as an administrative type of process that does not require respect of the principles of due process. If this is not true, or is not totally true, I would be grateful if the delegation could specify what are exactly the guarantees that are granted to the defectors concerned during this process, during the inquiry procedure, for instance, in terms of right to defense and maximum length of this process. And finally, Mr. Chairman, I would like to raise a larger issue and ask a question relating to the sense of perceived discrimination and unfair treatment, for example, at school or at workplace that the North Korean defectors allegedly feel. There are reports that has been brought to our attention the fact that among the North Korean defectors there is in fact a widespread sense of experienced discrimination. And this is confirmed inter alia by a survey on violations of human rights of North Korean defectors conducted in 2012 among 400 North Korean defectors. Can the delegation comment on these allegations and in particular on the effectiveness of an act that has been enacted in Korea, the North Korean Refugees Protection and Settlement Support Act, which is intended, in fact, to remove discrimination and stereotypes. Apart from this act, are there new initiatives that the government has taken or intends to take in order to face the challenge of these persistent cases of discriminations among
Muchas gracias a ustedes.
Thank you very much to you, Mr. Politi. Ms. Cleveland, you have the floor.
Thank you, Mr. Chairperson. And again, I would like to, since I'm taking the floor for the first time, thank the distinguished delegation from Korea for their responses yesterday and the anticipated ones today. I wanted to make a few short points. One is with respect to the LGBT issues raised yesterday and anti-discrimination. I just wanted to note that the point that my colleague Sir Nigel Rodley made about national consensus not governing human rights protections is also applicable to the state's failure to date to establish comprehensive anti-discrimination legislation, including based on sexual orientation and gender identity. And in this regard, I would appreciate it if the state party could respond to information we have been provided that South Korean government buildings were used to host conversion therapy seminars in November of last year and March of this year, which reportedly described homosexuality as a sinful disposition to be suppressed or disease to be cured. With respect to domestic violence, I would appreciate it if you could respond to concerns that the practice of suspending the indictment of domestic violence offenders on the condition that the offender undergoes counseling, and that addressing domestic violence through disproportionately light home protection measures allows perpetrators to avoid indictment or appropriate punishment and to perceive domestic violence as a non-crime. And then finally, with respect to migrant workers, I would welcome information regarding whether legal aid is provided to migrant workers to assist them in exercising their legal rights, and whether there are inspection, reporting, and monitoring mechanisms to ensure the protection of migrant workers in their workplace, particularly for agricultural workers. Thank you.
Muchas gracias.
Thank you very much, Ms. Cleveland. I think now the time has come to give the delegation some time in order to prepare their replies. We had 75 minutes of questions, so of course we have to bear in mind that it will be very difficult to be able to reply to such a large quantity of questions. The state will have the possibility to reply to as many as possible, and we will give them the time to do so. We will begin the discussion again at 12 on the dot, and I adjourn the meeting until then.